You're tuned into Agriculture Today, and we start our Wednesday show with an agricultural law update with K-State and Washburn law professor Roger McEowen. Roger, thanks for joining us again.
Oh, my pleasure, Shelby. Good to be with you.
Starting the show, I know that a lot of people have guests come out to their farming operations, and there are some liability concerns with that. And so what are some of those concerns for producers?
Yeah, that's right. Farmers, particularly in the past couple of decades, agritourism has picked up, and we've got a lot of types of agritourism activities on the farm that are used by farmers and ranchers to generate additional income. And so it's a nice new revenue stream that some farmers and ranchers find pretty profitable for themselves. And there are various laws that govern liability issues, so we're not really focusing on those today, but there are recreational use statutes that can apply to that provides greater liability protection. But anytime we have third parties, whether they're guests or not, come on the premises and they get injured somehow, then there's that potential that the landowner could be liable. And a lot of it depends on their particular status. Did we invite them to the premises? Were they an employee that's come to the premises for work? Are we benefiting somehow from them being there? Are they there to pick up milk? Are they a veterinarian that's providing a service? Are they a hunter on the premises with permission, without permission? A whole host of situations can arise where we have third parties on our premises as a farmer or a rancher.
A case that's happened that kind of touches on this is Jones versus Wright. So could you describe kind of what that case was and what that outcome also was?
Yeah, the Wrights always had a Christmas display, and it was called Wright's Lights, and this is a rural property. And they didn't charge people to come on their premises and watch the Christmas lights. You could walk around and see all the different lights. And this was down in Texas, and so we weren't worrying about snow or ice or anything like that in December. It was cool, but we didn't have the weather conditions that we would have in Kansas or places north. And this family came. They brought their young children, their minor children with them, and they parked on the Farm to Market Road, which is a rural road in Texas. They parked on the opposite side of the road from the landowner's property and came in on the property and looked at the lights. And then as they left, all of them made it across except one of the minor children. And as the minor child was crossing the road, there was a pickup truck that started down the road without its headlights on that ran over the child, resulting in a death of the child. The landowner gets sued out of this. The family sues them based on various theories, negligence as well as strict liability. And the issue, of course, was whether and to the extent the landowners that had the Christmas light display would be liable for these guests that were on their premises that were injured. In this instance, a child was killed as they were leaving.
And so definitely a sadder scenario there happening, but important to talk about. And what was the outcome? What did that case end up doing?
Well, the landowners won the case, and so they were not responsible for the death of the child. But it really turns on the facts of the case, and this is what people need to realize. Each of these cases, when negligence is involved or liability to a third-party entrant is involved, will turn on the facts of that particular case. Here the court said they didn't charge a fee for the lights, for looking at the lights. The vehicle that struck the child was being driven at night without lights. There hadn't been any similar prior accidents on the road. The landowners used loudspeakers to tell visitors not to park on the opposite side of the road. In fact, the local police department had put up signs telling people not to park on the opposite side of the road, but people continued to do so. And the court said, well, the accident occurred off the premises. They were on the public road after leaving the rural property. And the court said, when we look at all of those facts together, the landowners didn't breach any duty that was owed to the family. So without a breach of a duty, because there was no duty, then there's no liability. And so the child's death was not a foreseeable risk of looking at the lights as far as the landowners were concerned. So they weren't responsible.
A large combination of different factors coming into that, I feel like. And so for producers who maybe aren't putting up Christmas lights but are having guests come to their operation, what are some things that they need to think about maybe before inviting those guests or even opening up their operation to people?
Well, one factor that's important, and this is, we get a break on this by the recreational use statute in Kansas. I said we weren't going to major on that, but there's one point out of that I want to make, and that is that here the landowners in Texas didn't charge a fee, and the court pointed that out. So they weren't profiting from people coming in and looking at the lights. If you have an activity where you're inviting guests to your premises and you do benefit economically from it, that can increase your liability potential. Now, not in Kansas, because the Kansas statute says that a rural landowner, a farmer, or a rancher can still charge a fee for recreational activities on the farm. Now, this would be a recreational activity, looking at Christmas lights. So that's a unique aspect of the Kansas law. But the fact that this occurred off the premises, based on all these other factors, was also in the landowner's favor. Now, for farmers and ranchers that are inviting people to the farm, say for a hayride, or maybe you've got a corn maze, or you've got a U-picket operation, something like that, you always want to have a good comprehensive liability insurance policy in place that makes sure that it covers the risks that you're wanting coverage against. Now, your general farm comprehensive liability policy will only cover risks associated with the farming activity. So you need an additional rider to cover these non-farm activity risks. That's an important point. You just don't think that your general comprehensive farm liability policy will cover these other activities that you're having people on the premises for. Talk with your insurance professional, probably get an additional rider to that policy to cover non-business pursuits of the insured. That's the key language that you want to look for. That's a good place to start. But anytime you have guests to the premises, that increases your potential for liability, and that's kind of the overall theme that people need to remember.
And another thing, talking about customers and consumers coming to operations or dealing with operations, direct beef sales and custom agreements. Also an important thing to a lot of farming operations. And so why is it producers make sure that they have all their ducks in a row for when they're in that part of their farming operation?
Yeah, that's right, because the law treats the producer differently when the live animal is sold to the buyer compared to if the sale of processed beef is what is sold. Now, if you want to buy beef directly from a cattle producer, what the law does is treat that transaction differently, depending on whether you're selling a live animal or not. And then the matter turns on whether the animal owner is the end consumer. And that's the key point. If the cattle producer sells processed beef to the buyer, well, then we have a bunch of rules that come into play with respect to the processing of that beef. The animal that's processed, the processing of it has to occur in an inspected facility. The producer is also subject to licensing and labeling and insurance requirements. But if the producer sells the live animal to the buyer, then it becomes the buyer's animal, and the buyer can do what they want in terms of having that meat eventually processed. That allows the producer then to do the processing if the buyer wants the producer to do it, because it's the buyer's animal. It's not the producer's animal. And then the farmer can sell any remaining beef not initially purchased to another buyer. So that means that we need to control that purchase arrangement by contract and clearly state that it is the live animal that's being sold and the percentage of the live animal that's being sold, not the processed meat.
And so having things wrote down and specifically showing what things are happening are very important in this scenario?
Absolutely. If you're selling the specific animal, that animal needs to be identified, the calculation of the price needs to be detailed, how you're going to make payment, that needs to be specified. Plus any processing fees should be set forth, as well as making sure that the purchase agreement is clear that the meat can't be resold or donated. And make sure to clearly state when the animal is the buyer's property. When does title, so to speak, transfer to the buyer? But the key point is that the owner of the animal and the consumer of the beef have to be the same person. So make sure, I think the take-home out of this one is make absolutely sure if you're going to do this, that you have a good custom harvest agreement so that you can use that custom exempt processing option that's in the law. And
we're mentioning beef a lot here, but is this applied to a lot of the different livestock species?
You're right. That's a good point, because I focus primarily on beef because that's where we see the vast majority of these types of arrangements rise. But it could be with other types of food products and other types of animals also. Same principles would apply.
So, Roger, if people are coming to your farm to look at it or buying product from your operation, what are the key things that you want producers to do and think through before they let those different options happen?
Yeah, well, I think it's good that we tied both of these topics together in one program, because anytime you have people coming to your premises, particularly for a business purpose, which means you are benefiting economically from it, you have to realize the heightened potential for your liability risk And then if they're buying a meat product such as beef products, make sure you've got a contract that says they're buying the animal, if they want to buy direct from you, rather than the processed beef. Those 2 points are good to discuss together.
Roger, I appreciate you taking the time to join us today and giving us some more information on some agricultural scenarios.
Thank you, Shelby. My pleasure.
That was Kansas State University and Washburn Law professor Roger McEowen as he discussed liability for guests on the farm and direct beef sales and custom agreements. If you would like to read more on these topics, you can do so by going to his blog, which will be linked in today's show notes, or you can find it by going to washburnlaw.edu/Walter. Again, that is washburnlaw.edu/Walter.